అందరికీ నమస్కారం అండి. వెరీ గుడ్ మార్నింగ్ టు ఆల్ ది యంగ్స్టర్స్ అండ్ ఆల్సో ది పబ్లిక్ వాచింగ్ this video. On the previous video number 1, ఆస్తి బదలాయింపు చట్టం గురించి, ట్రాన్స్ఫర్ ఆఫ్ ప్రాపర్టీ గురించి బేసిక్స్, అంటే ఏ బదలాయింపులు యాక్ట్ 10లోకి వస్తాయి, ఏ బదలాయింపులు రావు, అలాగే ఎన్ని చాప్టర్లు ఉన్నాయి, వీటి గురించి ఫండమెంటల్స్ గురించి వీడియో నెంబర్ 1లో చెప్పడం జరిగింది. ఇప్పుడు ఇవాళ వీడియో నెంబర్ 2కి ఫర్దర్గా సెక్షన్స్ 1, 2, 3 కాడి నుంచి సెక్షన్స్లో ఏమున్నాయి అనేది క్లుప్తంగా చెప్పే ప్రయత్నం చేస్తాను. సో హియర్ ది యాక్ట్ అప్లైస్ టు ది హోల్ ఆఫ్ ఇండియా, దట్ యూ మస్ట్ రిమెంబర్. Previously there was some restriction to some states like Bombay and all, but those are all over. Now you have to only remember that it applies to whole of India. And this act covers a substantive rights, not procedural. So why I am telling it is a covering codification of substantive rights, because the law covering substantive rights will never have a retrospective effect. అంటే గతం అన్నట్టు యాక్ట్ రాకముందు గతంలో జరిగిన రైట్స్ గురించి, లయబిలిటీస్ గురించి ఈ యాక్ట్ అప్లై కాదు. సో దిస్ యాక్ట్ సేవ్డ్ సర్టెన్ ఎనాక్ట్మెంట్స్, రైట్స్ అండ్ లయబిలిటీస్ బిఫోర్ ది యాక్ట్ కేమ్ ఇన్ టు ఫోర్స్. దట్ ఈస్ ది మీనింగ్. సో యాజ్ సచ్ ఇట్ ఈస్ నాట్ హ్యావింగ్ any retrospective effect, this being a law covering substantive rights, not procedural. So this you must remember. Then coming to section 3. Section 3 is a interpretation clause, and it is most important because there are so many definitions which are very much important, not only on the point of Transfer of Property Act, but also in it covers all civil laws. It will be helpful to a civil advocate while dealing with other acts also. So it is very important to understand these definitions, not only the advocates, younger advocates, that also but general public and others, because every day in దైనందిన జీవితంలో ఆస్తి బదలాయింపులు జరపకుండా ఎవరు ఉండరు. ఇట్ ఈస్ ఎ కామన్ నవేడేస్. సో కాబట్టి సబ్జెక్ట్ అర్థం చేసుకుంటే జనరల్ పబ్లిక్ కూడా ఇట్ ఈస్ ప్రతి ఒక్కరికి కూడా ఇది చాలా ఉపయోగకరంగా ఉంటుంది. సో నౌ కమింగ్ టు సెక్షన్ 3 ఇంటర్ప్రిటేషన్ క్లాస్. నౌ వాట్ ఈస్ ఇమ్మూవబుల్ ప్రాపర్టీ? సో this is not defined in the act. Why it is not defined? It is only says that immovable property does not include standing timber, growing crops or grass. That's all. It only says the immovable property and స్థిరాస్తి does not include standing timber, growing crops or grass. And the word property also is not defined in the act. There are two types of properties we all know, that is immovable property and movable property. Then when the act is in the act, that is in the Transfer of Property Act, there is no, the definition is not described regarding immovable property, then we have to go to other acts. In other acts how it is defined. Now coming to section 3(25) of General Clauses Act defines immovable property as it shall include land, benefit to arise out of land. This is most important. Land and benefit to arise out of land, things attached to earth are permanently fastened to anything attached to the earth. So this is another important definition under section 3(25) of General Clauses Act. Here what is benefit arising out of land? So to understand this, I will give you one simple example. For a common people, For that matter, if someone asks whether a fish is a mobile property or immobile property, maximum people will say mobile property only, because by nature of its movements. But under the TP Act, benefit arising out of land. Now, under TP Act, the Supreme Court time and again said that the fish in the pond or tank is a profita pendere, that means benefit arrived from the land. So, it is immobile property. So, now this it is quite against to the normal thinking. So, that is the beauty of this benefit arising out of land. So, now in order to understand that how a right to catch and carry away the fish from the tank or pond is profita pendere and it is benefit arising from land, as such it is an immovable property, you have to go through. I will give two judgments. There are couple of judgments are there, but two important judgments I will give. You please go through, so that not only benefit arising out of land, there are so many other points discussed in that judgments. If you read that judgments comprehensively, you will improve a lot as far as Transfer of Property Act is concerned, and your any doubts if you have, those will be removed. So, that judgment is 1977 Supreme Court, page 2149. I repeat, 1977 Supreme Court, AR 1977 Supreme Court, page 2149. The parties are Behar Fishermen Cooperative Society versus Sipahi Singh. So, in this judgment, there is a dispute as to the registration of lease deed. Then the ultimately Supreme Court has held that a right to catch fish and carry away the fish is a profita pendere and it is a benefit arriving from the land. As such, it is an immovable property. As such, it has to be, lease deed has to be registered compulsorily as of immovable property. That is the, just I am giving an hint, but you go through the entire judgment. Then another judgment I am giving is AIR 1996 Supreme Court, page 207. I repeat, AIR 1996 Supreme Court, page 207. Parties are Santosh Jaiswal versus State of MP. This is also a similar proposition is held. This is regard to, I think, security bond. So, we call it as a mortgage deed. So, whatever it may be. The ratio of these cases are that, the ratio decidendi of these cases are that right to catch and carry away fish in the pond or tank is a profita pendere, that is benefit arising out of land. So, it is an immovable property. So, this is how we have to understand the benefit arising out of land. Then coming to things attached to earth or permanently passed into anything attached to that I will come. Then in Indian Registration Act also, we find the definition of immovable property. According to Indian Registration Act, immovable property includes land, building, hereditary allowances, rights of ways, lights, ferries, fisheries, just now I spoke, or any other benefits to arise out of land and things attached to earth, but not standing timber, growing crops or grass. This is what the definition that is described in the Indian Registration Act. Then what is the meaning of attached to earth? The expression attached to earth meaning rooted in the earth, as in case of trees and shrubs, or embedded in the earth, as in the case of walls or buildings, or attached to what is so embedded for the permanent beneficial enjoyment of that to which it is attached, as for instance doors, windows, etc. So, this is the meaning of attached to earth. Then the courts have recognized some of the rights as immobile property. So, just now I said about, I gave two judgments regarding right to catch fish and carry away is an immobile property. Similarly, the courts have already decided certain rights as immobile property. So, I will give briefly what are those rights. That is right of way, already it is there in the definition of Indian Registration Act. Right to collect rent of immobile property, right to collect dues from fairs held on plot of land, right to ferry, right of fishery, office of a hereditary priest of temple, a Hindu widow's life interest of the income of the husband's property, a mortgage's right to redeem the mortgage, right to collect lac from trees and a factory. So, these are all recognized by the honorable courts, the honorable High Courts and Supreme Court of India. These rights comes under immobile property. Sirasti kinda vastayi anni. Next, some rights, the courts held that some rights are not to be immobile property. What are those rights? A right of worship, the right of a purchaser of property to have it registered in his name. Royalty, a piece of machinery which is not permanently attached to the earth and which can be shifted from one place to another. A decree for the sale of mortgaged property. A right to recover maintenance allowance even if such an allowance is charged on immobile property. The government promissory notes, standing timber, growing crops and grass. This continues. So, these are all the rights the courts held that they are not to be immobile properties. So, this is a summary I have given because these are all covered by one or other the judgments of the Honorable Supreme Courts and High Courts, because just I have given two judgments of that regarding benefit arriving from the land, what it is. So, like that these are also covered under various judgments of the superior courts. So, from those judgments these were taken. So, what are all the rights covers under immobile property, covered under immobile property, what are the rights not to be immobile property. So, these are all very important. Now, the question may come, the reason for providing that standing timber, growing crops and grass are not to be regarded as immobile property. So, this depends upon the purpose for which that things are sold. Just listen, is important. For instance, timber is sold, it is to be cut and taken away. It will no more have any connection with the land and it is therefore not immobile property. On the other hand, A gives a right to B to remove all trees which may grow in A's forest for the next 10 years. This is not a transfer of immobile property. The trees thrive on the land and continues to be depend on the land for the next 10 years and therefore, it is a transfer of an interest in land, that is an immobile property. Here the term standing timber refers to the trees which are fit for use for building or repairing houses, which are fit for use for buildings and repairing houses. In order that tree may be considered to be standing timber, they must be trees where wood is suitable for building houses, bridges, ships, etc. For instance, oak tree, elm tree in England and the neem tree or teak tree in India. They would be standing timber only if they are in such a state that if cut and they would be used as timber. So, that is why this standing timber is not included in immobile property. Similarly, growing crops which are being cut and grass, cut and separated. Similarly, mortgage debt, whether immovable property. So, the debt secured by a mortgage of immovable property will now be treated as immovable property, particularly after amendment of definition actionable claim in section 3 of this act. Then movable property. The movable property also it is not defined in the act, but as seen from the general clauses act, property of every description except immovable property. In other words, all property which is not immovable property is movable property. A very simple way they have given. Then next వచ్చి section 3 కింద what is an instrument. So already in the first video I have already spoken about this. Instruments here means a non-testamentary instrument. A testamentary instrument like will is not coming under this act, that already I have told. So here instruments mean non-testamentary instrument. Will or codicil it will not cover. This is about immovable property and movable property. So I have not only given definitions from General Causes Act and Indian Registration Act, but also some citations regarding benefit arising out of land, which is an immovable property, that a fish in the tank is immovable property, and also what are all the rights recognized by the courts as immovable property and what are all the rights not recognized by the courts as immovable property. So, this is about interpretation of immovable property and movable property. It is very much necessary and important. Then instrument, already told. Then next comes another important aspect is attested. What is the meaning of attested? It is another important term which you come across every day. ఆస్తి బదలాయింపు ఎప్పుడు జరిగినా కూడా ఇది అటెస్ట్ అనే మాట మనం వింటూ ఉంటాం. అటెస్ట్ అంటే తెలుగులో ఏంటంటే ధృవీకరించడం. అటెస్టెడ్ అంటే ఏమి ధృవీకరించడం? దట్ ఇస్ వాట్ వీ విల్ సీ ఇన్ దిస్. హియర్ ఈ అటెస్టెడ్ సంబంధించి ఇఫ్ యూ గో టు ఇండియన్ సక్సెషన్ యాక్ట్ సెక్షన్ 63 and also subsection 3 of section 3 of Transfer of Property Act, attested in relation to the instrument means attested by 2 or more witnesses. 2 or more witnesses and minimum 2 witnesses, because for attestation, so more than 2 can be there, but minimum 2 must be there, particularly in compulsorily attestable documents such as gift, mortgage, etc. Will, of course, will is there, but we are not Transfer of Property Act, it is a testamentary document. So, will we are not now discussing it. So, what is attested means? By 2 or more witnesses, each whom has seen the executant sign or affix his mark to the instrument, seen some other person sign the instrument in the presence of and by the directions of executant, received from the executant a personal acknowledgement of his signature or the signature of such other person, signed the instrument in the presence of executant. So, what is this meaning? To simplify this, suppose a gift is executed by a donor. So, donor, after executing the gift, the witnesses and donor both should witness each other. Both should see. When the executant is signing, he should sign in front of the, when witnesses are seeing. And when witnesses are signing, the executant, it should be before the executant. So, both witnesses, attestors and executant should witness each other while they are signing. That is in a simple common parlance. But ikkada received from the personal acknowledgement signature or signature of that other person. Even if executant acknowledges the contents and his signature, that it is my signature, that time also a witnesses can sign on his acknowledgement. Then these people should sign before the executor. So, here it is not necessary that all witnesses should be present at the same time. Also, no particular form of attestation is necessary. So, this is about attestation. But here attestation, there is a vast, it has grown into a vast subject. Anyway, now I am not going to the proof and evidence act. That will be separately we can discuss on some other occasion. Now, only what is attested, who are the attesters. To that extent only I will confine myself. So, now as far attestation is concerned, I already told ధృవీకరించడం. ఏమి ధృవీకరించడం? To sign and witness any fact, the fact of execution by the executant. The word attested in this section means that a person has signed the document by way of testimony of the fact that he saw it executed. The party who sees the document executed is in fact a witness to it. If he subscribes as a witness, he becomes an attesting witness. Now, the law does not require all documents to be attested. Thus, mortgages and gifts must not only be in writing, but must be attested. Documents affecting sales, exchange and leases need not to be attested, but need not to be attested in the context of attestation described in the act. But normally, to have some authenticity to the document, the sales and other documents also normally for the purpose of ధృవీకరించడానికి, అంటే ఎగ్జిక్యూటెంట్ యాజ్ ఎగ్జిక్యూటెడ్ ఏ సేల్ డీడ్ అని యాజ్ ఏ కాషన్గా అటెస్టర్స్ని పెట్టుకుంటారు. దట్ ఈస్ ఇన్ ఏ ప్రాక్టీస్ ఇన్ వోగ్. బట్ హియర్ వాట్ దిస్ మీన్స్ ఈస్, ఇన్ కంపల్సరీలీ అటెస్టబుల్ డాక్యుమెంట్ దేర్ షుడ్ బి 2 or more witness. It is a compulsion. What they mean? But other documents it may not be. But these documents, compulsorily attestable documents like gift, mortgages and all, it is a compulsion. That I told will also is there, but it is being a transfer of property act, we are not going that to that end. Then here, as far as attestation is concerned, there are a lot of case law is developed. Why so much case law? It is simple attestation, 2 people attesting is enough. Normally common man may think, but suppose the attesters actual attesters are not in a position to come to court and give evidence to the effect that the document is executed and the executant signed before them in order to prove such compulsorily attestable document. Then what is next alternative? Then one question came whether identifying witnesses, scribe or registrar, certifying registration. Suppose if a gift deed is registered, on the back side of the first page, normally identifying witness will sign identifying the executant, and also registrar will certify and he will sign that it is registered before him and all the fees has been paid as required under Stamp Act and Registration Act. And the scribe who scribes the document at the instructions of executant, he says as scribe. So, these 3 people can be treated as attesters and their evidence can be accepted as attesters is the question before the various courts. It is a practical problem. Then can they be attesters? Then the Honorable Supreme Court has an occasion to discuss about these aspects as far as in 1969 in M.N. Abdul Jafar versus H. Venkata Shastri and Sons, reported in A.R. 1969, Supreme Court 1147. I repeat, A.R. 1969, Supreme Court 1147. I am also giving names. Suppose if the page number happened to be wrongly noted, you can take out these decisions by typing the names M.N. Abdul Jafar versus H. Venkata Shastri. This Venkata Shastri and Sons, Venkata Shastri's case is more important on this aspect. So, what their lordships held is that there should be animo attestandi that means for the purpose of certifying that he saw the executant sign the document. Ultimately, they held that the identifying witnesses and scribe and register, their purpose and their animo attestandi they will not come under that head, because their purpose of signing is entirely different. It is not at all for they can be considered as attesters for one because the reasons are that identifying witness signs, a purpose of identifying is different. The registrar signs, the purpose of signing putting signature by the registrar is different, because it is statutory authority signing, certifying that it is registered after complying with the provisions of Stamp Act and Registration Act, and scribe's role is different. None of these people comes under animo attestandi. Their intention is not to be as attesters. So, this is this important judgment. Here, so much case law is discussed. At one point of time this side, another point of time that side, so much case law discussed, and ultimately now as I have discussed, these three identifying witnesses and scribe and registrar cannot be treated as attesters, because they are not coming under animo attestandi. So, this is an important judgment, Venkat Shastri judgment. You please go through. You will, after going through this comprehensively, your doubts regarding attestation will be removed. Not only will be removed, you will be able to tell to your colleagues or juniors whoever required knowledge about this subject. So, this please read this judgment. So, what is the animo attestandi means? For the purpose of certifying that he saw the executant sign the document. So, if a person puts his signature on a document for any other purpose, that is, for example, signifying his approval to the transaction, he is not an attesting witness. Just I told identifying witnesses, registrar and scribe. So, that is mere attestation of document is no proof of the fact that attesting witness is aware of the contents of the document. He need not to be. The executant acknowledges, that's all. He need not to personally know the contents, attesting witness. And in some transactions, he was present at the time at the transaction and attested after hearing, having heard the contents, having knowledge of the contents. It is held by the courts that afterwards he is stopped from challenging the right of the transferee. He need not to know, but in some occasions, suppose when it comes, suppose sale deed somebody has executed, just for example I am giving. Father sells some property, and as an abandoned caution, the major sons, one of the sons also subscribes his signature as one of the attester after knowing the contents of it. Afterwards, he cannot file a suit that my father sold the property without my knowledge. He is stopped from questioning the rights of transferor. So, only this is what it means. Suppose, what is the effect of invalid attestation? If the attestation is invalid, the document cannot be enforced in the court of law. If deed is a mortgage, it can neither operate as a mortgage nor as a charge under section 100. When it comes to English law, the attesting witness should be present at the time of execution and should be able to testify that the deed was voluntarily executed by a proper person. But this requirement is not necessary in Indian law. So, this is what about the attestation, and this, to know about the scope of this attestation, I have given the judgment that one has to go through comprehensively. You will acquire more knowledge about the attestation. You will be able to tell to somebody that it is attestation, these are all the people comes under attestation, and these are all the witnesses, they cannot be treated as attesters. These all things will be there. Then next comes here As far as the attached to earth is concerned, one more important thing is that suppose a tenants of a cinema hall install a generator in order to run the cinema in case of power failure in the leased premises, not with an intention to make a permanent improvement to the premises, but with the object of utilizing the machinery for their own profit so long as they had the use of premises and selling it if and when their lease terminated. So, a security bond pledging the oil engine was held not to be a transaction relating to immobile property. So, these are all the case law that is developed, depending upon the utility of particular item, particular mission or particular property, it will be decided whether it is a immobile property and mobile property. Then comes actionable claim. So, actionable claim is concerned, it is discussed in the chapter 9, and we will, when it comes there, we will definitely discuss regarding actionable claim. The next chapter is notices under section 3. Here the notices is actual notice and constructive notice. This is also a vast subject. So much case law is developed on this, and it is very much interesting, and you will appreciate also this. So, as far as the notice is concerned, this needs a separate video. As far as today's this thing is concerned, about what is immobile property, what is mobile property, what is the benefit derived from the earth and the citations, and about the attestation, and who are not persons not covered under not coming under attesters, and also citation. These are all the important aspects we have discussed. You please listen the video and put your comments, and next we will go to notice. Thank you very much. We will meet in the next video.
సెయింట్ జోసెఫ్ విద్యా సంస్థల చైర్మన్ మహాఘన జయరావు పొలిమేర గారి సారథ్యంలో సెక్రటరీ అండ్ కరెస్పాండెంట్ రెవరెండ్ ఫాదర్ జి మోజెస్ గారి స్వీయ పర్యవేక్షణలో సుశిక్షితులైన డెంటిస్టులను తయారు చేయడంలో అహర్నిశలు కృషి చేస్తోంది సెయింట్ జోసెఫ్ డెంటల్ కాలేజ్ అండ్ హాస్పిటల్. స్పేషియస్ లైబ్రరీ, వెల్ ఎక్విప్డ్ ల్యాబ్, oral microbiology and nanoscience research center for better academic experience. Education delivered by highly skilled teaching professionals, accredited with NAC A grade. BDS మరియు MDS లలో అడ్మిషన్స్ కొరకు సంప్రదించండి. డెంటిస్ట్ కావాలనే మీ లక్ష్య సాధనలో మీకు తోడ్పడుతుంది సెయింట్ జోసెఫ్ డెంటల్ కాలేజ్ అండ్ హాస్పిటల్, దుగ్గిరాల, ఏలూరు.